Nature of judicial review, rule scripts. Rule 1, Article 3 of the Constitution empowers Congress to create all federal courts. The Constitution created the Supreme Court of the United States. Article 3 empowered Congress to create all federal courts. The Constitution itself created the Supreme Court. Okay, try that one more time. Article 3 empowers Congress to create all federal courts. The Constitution itself created the Supreme Court. Okay, that's the easy part. Now let's talk about the Supreme Court's original exclusive and original discretionary jurisdiction. Okay, the Supreme Court has original and exclusive jurisdiction over one thing: cases and controversies between two states. I repeat, the Supreme Court has original exclusive jurisdiction over cases and controversies between two states. What does this mean? This means that the Supreme Court must hear cases and controversies between two states. So let's incorporate those into our rule statement. Pursuant to the original and exclusive jurisdiction of the Supreme Court, the Supreme Court must hear cases and controversies between two states. Let's say it a different way. The Supreme Court must hear cases and controversies between two states pursuant to its original and exclusive jurisdiction. The Supreme Court must hear cases and controversies between two states pursuant to what? That's right, its original and exclusive jurisdiction. Okay, so that's the must hear. They must hear cases and controversies between two states. Now let's go over discretionary. Discretionary is what the Supreme Court may hear. The Supreme Court, here's our rule script number 3. The Supreme Court may hear cases and controversies involving ambassadors, public ministers, and councils between the United States and a state, and between a state and aliens. So that the Supreme Court has discretion to hear cases between 1, ambassadors, 2, public ministers and councils, and between the United States and a state, or between the United States and who? Aliens. The Supreme Court may exercise its original discretionary jurisdiction to hear what? Cases regarding ambassadors, public ministers and councils, between the United States and a state, and between the United States and who? Aliens. USA and a state, USA versus aliens, ambassadors, public ministers, and council. That's discretionary. Okay, a state includes all local and municipal governments because local government actions are what? Imputed to the state in which they sit. So when we discuss states, we are also discussing local and municipal governments. A state includes what? All local and municipal governments because local government actions are imputed to the state in which they sit. Okay, original exclusive, cases or controversies between two states. Original discretionary, ambassadors, public ministers, and councils, USA and a state, USA versus aliens. Okay, next up is Congress's power to define and limit the judicial power of the Supreme Court. Remember, the Supreme Court has original and exclusive jurisdiction over, that's right, cases and controversies between two states, and discretionary original jurisdiction over, that's right, ambassadors, public ministers, and councils, the USA and a state, and the USA and aliens. And state includes what? Local and municipal governments. Our next rule is that Congress has the power to define and limit the appellate jurisdiction of the Supreme Court. Congress may not expand or reduce the original jurisdiction of the Supreme Court, but Congress may limit or define the appellate jurisdiction of the Supreme Court. So this is our rule script. Part 1, Congress may not expand or reduce the original jurisdiction of the Supreme Court, but Congress may limit or define the appellate jurisdiction of the Supreme Court. Try to say the whole thing. Congress may not, that's right, expand or reduce what kind of jurisdiction? The original jurisdiction of who? That's right, the Supreme Court. But Congress may limit or define the what? That's right, appellate jurisdiction of the Supreme Court. How can they do this? Okay, Congress has authority over the federal Article 3 courts. Remember, those are our district courts. They can create any inferior court they deem necessary and define its scope, trial courts and appellate courts, and limit the types of cases those courts may hear. All right, so here's our rule. Congress may not expand or reduce the original jurisdiction of the Supreme Court, but Congress may, that's right, limit or define the appellate jurisdiction of the Supreme Court. What can they do? Congress has authority over the, that's right, federal Article 3 courts. They can create any inferior court and define the scope of its jurisdiction and the types of cases those courts may hear. So the federal Article 3 courts, they can create them, they can define the scope of their jurisdiction, and they can limit the types of cases those courts may hear. Okay, so Congress may not eliminate an entire area of law, but they do have authority over the federal Article 3 courts. They can create the inferior courts, they can define the scope of their jurisdiction, and they can limit the types of cases the courts may hear. Those are the Article 3 courts. Those are our district courts and our courts of appeal. Now, the Article 1 courts. Article 1 courts are our specialty courts, tax courts, military courts. Okay, there's one difference between the Article 1 and the Article 3 courts, and that's the judges. Federal judges in a district court, court of appeals, or the Supreme Court, oh, how long do they serve? That's right, life on good behavior, and they can't have their salaries reduced. But the Article 1 courts, the tax courts, the specialty courts, the military courts, the judges don't have lifetime tenure and their salary can be decreased. And that is it for the nature of judicial review.